As long as given the no arguments, you hew the line concerning the first 30 minutes, which are now 25 minutes.
I certainly will try to. And before I begin, I would like to acknowledge I'm here with my associate, Shane Felton, and co-counsel, Karen Kenny Bronco. As this court is aware, the issue in this matter is whether or not New Jersey should become the only state in the entire country to apply its constitution to the rules of a private, voluntary homeowners association regarding internal issues that deal solely with its own members. Even though this court, now the lower courts, with the exception of the appellate division in this matter, uniformly have applied the business judgment rule to such decisions of homeowners associations. In fact, the courts of 24 other states and the United States Supreme Court have indicated that they would not apply the Constitution to such private matters. There are three overriding reasons why this court should join all these other courts and not apply the Constitution to the internal rules of homeowners associations for their members. First, this court very clearly required that under the Schmidt Coalition test, the public must be invited to use the property at issue for public purposes before the Constitution can be applied. Of course, in this matter, the public is not invited into Twin Rivers for expressive purposes, and indeed is not even allowed to rent the community room, have access to Twin Rivers newsletter, or put signs on property in Twin Rivers. Only residents in Twin Rivers are entitled to do so. As a result, under the Schmidt Coalition test, the Constitution should not be applied in this case. Second, the business judgment rule has been the historic standard uniformly applied in New Jersey with regard to the actions of homeowners associations. The appellate division in this matter grossly mischaracterized this court's analysis in the Schmidt Coalition cases by changing it to include the private actions of a homeowners association dealing with its own members, rather than applying the business judgment rule. As demonstrated by the trial court's decision in this matter, our courts have been able to adapt the business judgment rule to association rulemaking with extremely just results. Third, the appellate division plaintiffs improperly distorted the distinction between owners of private property in this case, whose rights are governed by their contract with the association, and the public. For example, they have suggested that the Constitution must be applied because an association's members should not lose their constitutional rights or have any less rights than the public. I suggest to the court this is a red herring. In fact, members of the association actually have more rights than the public on Twin Rivers property. Members are protected under statutes such as PREPA, the Nonprofit Corporations Act, and the Condominium Act, regulations, the oversight of the Department of Community Affairs, the application condominium. And that may very well be, and that is the case, Your Honor, because here, and it comes back to your question about a contractual relationship. This person bought the unit in question, bought property there, with the knowledge that this was going to be a condition. It was part of a restrictive covenant that they entered into. The three plaintiffs in this matter, all had attorneys representing them when they bought into these units. So they knew what they were getting into in this situation. It's a choice, a lifestyle choice that people make. And it's for the greater good of the community, if you will, of Twin Rivers. So that's a decision that they contractually have agreed to. And understandably so. Our activities. We are dealing here with private property, not a mall situation, where people have agreed to certain restrictive covenants. And so people have certain... I'm sorry, Your Honor.
No. And one of your arguments is, based upon those rules, regulations, and restrictive covenants, people buy into the community. People might not want to buy into the community if there's unregulated signage and other things that destroy the aesthetics of the community.
And may deal with the actual worth of that community.
Exactly right. It could diminish the value of their properties, which is why the association works for the greater good. The only other thing I was going to point out to Your Honor, this is a very different situation than the mall situation. And
I'm not arguing for it or against it. I'm merely trying to explain what might have motivated the appellate division to point out all of these factors.
Well, I would just suggest one thing that they didn't consider in trying to weigh these factors is that In the mall situation, in the university situation, the people who are invited onto that property have no say in what the rules are going to be governing those invitees, the public. They have no protections. They don't have PRED for the Condominium Act or any statutory protections. They don't have the Department of Community Affairs overseeing their activities and what happens there. They don't even have the business judgment rule to protect them if the mall or the university makes a bad decision. Here we're dealing with people who have protections. The people who agree to move into a homeowners association don't need the constitutional protections that this court found so necessary for other people who otherwise didn't have any say in what the rulemaking was going to be.
It would compel the association to print messages that they do not want to print. It would compel them to use their resources to disseminate those messages. And it would compel them to reduce the space for their own messages to accommodate other people's messages. And that is what the U.S. Supreme Court has said is a direct violation of the First Amendment. They sent a flyer to all the members to inform them. For example, the association decides we need to renovate the clubhouse. They send out a flyer to everyone. They say we're going to renovate the clubhouse, and here's why we're going to do it. Here's why we need to spend the money. Do the members have a right to have something inserted in that flyer opposing it? Do the members have the right to force the association to send a flyer giving their position? I think the answer is no.
Your argument is that the First Amendment protects you from having to express their views.
That's correct. That's correct. And it also goes further than that, though. Not only express their views, but reduce my ability